Hello dear aspirants, welcome to Epitome IAS. So we are doing the UPSC PYQ analysis. Today's topic is judiciary from the Indian polity. So let us start with the first question. Consider the following statements. Statement 1, pursuant to the report of H.N. Sanyal Committee, the Contempt of Court Act 1971 was passed. Statement 2, the Constitution of India empowers the Supreme Court and the High Court to punish for the contempt of themselves. And statement 3, the Constitution of India defines the civil contempt and the criminal contempt. Statement 4, in India, the Parliament is vested with the powers to make laws on the contempt of court. So in this question, they are talking about the contempt of court. Okay. The first statement says that the Contempt of Court Act 1971. This act was actually enacted based on the recommendation of H.N. Sanyal Committee. This is what the first statement says. Is that true? Technically, yes. After this H.N. Sanyal Committee's recommendation, this particular act, the Contempt of Courts Act 1971, this particular act was passed. Okay, so we can say this statement is a correct statement. Then statement 2, the Constitution of India empowers the Supreme Court and the High Court to punish for contempt of themselves. So if you see here, whenever we are talking about the power to punish for the contempt, let us say in case of a Supreme Court, yes, the Supreme Court has the power to punish those who are contempt, of the Supreme Court. The High Court also has the power to punish those people who are contempt, the High Court. So this power is actually available to both Supreme Court and High Court. Okay, and they are saying that yes, both Supreme Court and High Court, they are empowered by the Constitution of India to punish for the contempt of themselves. Themselves matlab in case of Supreme Court, whoever is contempt the Supreme Court. In case of High Court, the contempt of High Court. Okay, that like that. So yes, this statement is also a correct statement. Statement 3, the Constitution of India defines civil contempt under criminal contempt. As I already told you, like in many questions, we are constantly seeing that whenever they are mentioning, or whenever they are saying that in a particular statement, that the Constitution of India defines this particular term, or let us say they are saying this particular term is specifically mentioned in the Constitution of India. If they are saying that specifically, then you have to check once again whether we have read this or not. Okay, because most of the cases, in most of the cases, many terms it is not actually defined by the Constitution of India. And in some cases, the terms are actually not even mentioned in the Constitution of India. Okay, so when they are saying the Constitution of India defines these two terms, then obviously there is some check there. Okay, technically, no, these two terms are not at all defined by the Constitution of India. Even though these two terms are mentioned in the Constitution of India, the Constitution of India does not define what are these two terms. Okay, so technically this act, the Contempt of Court Act 1971, this particular act actually defines these two terms, not the Constitution of India. Okay, so we can eliminate this option. Then statement 4, in India, the Parliament is vested with powers to make laws on contempt of court. Now you try to answer this particular statement. Is it correct statement or is it a wrong statement? What they are saying is this contempt of court, regarding contempt of court, the Parliament has the power to make laws. That's what they are saying. In the first statement, if you see, they are talking about this Contempt of Court Act 1971. So technically this act, obviously it is an act. Who will make this act? An act will be enacted by the Parliament of India. If Parliament of India does not have the power to enact laws on the contempt of court, then how can this act be enacted? So right, the common sense, by using common sense, we can say that yes, the Parliament of India It has power to make law, to enact law on the contempt of court. Okay, so we can actually say this particular statement is a correct statement. Okay, so if you see here, option 3, statement 3 is wrong. We can eliminate statement 3. C is gone, D is gone. You are left with two options, A and B. Now, we already know that 1, 2 and 4 is the correct answer. Option B is the correct answer. Okay. Now, let us see the explanation. The Contempt of Court Act 1971 was actually passed based on the recommendation of H.N. Sanyal Committee. Okay, based on the H.N. Sanyal Committee only, on the recommendation of H.N. Sanyal Committee only, this particular act has been enacted by the Parliament. Okay, then the Constitution of India empowers the Supreme Court and the High Court to punish for contempt of themselves. So when there is a contempt of Supreme Court, the Supreme Court has the power to punish. And whenever there is a contempt of High Court, then the High Court has power to punish them. Okay, so both Supreme Court and High Court, they both have power to punish the contempt of themselves. Then if you see here, Article 129 of the Constitution clearly mentions that it empowers the Supreme Court to punish contempt of Supreme Court itself. Okay, Article 129. And if you see here, Article 250, 215, it empowers the High Court. It empowers the High Court to punish for the contempt of High Court. Okay, so technically, the Constitution of India empowers both Supreme Court and High Court for the contempt of themselves. Okay, so that's the thing. Then, while the Contempt of Court Act 1971, it defines the civil contempt and the criminal contempt. So both these terms, civil contempt and the criminal contempt, is defined in this particular act, the Contempt of Court Act. But it is not actually defined by the Constitution of India. It is actually mentioned in the Constitution of India. Okay, these two articles we right now saw, just now saw, right? So they have mentioned these two terms, but they have not defined these two terms. Okay, now the Constitution of India does not explicitly, it defines, whenever they are asking, whenever they are saying the Constitution of India defines this particular term, yes, you have to see it. Okay, then in India, the Parliament is vested with the powers to make laws on the contempt of court. As I already told you, when the Parliament, it is not having the power to make law on the contempt of court, then how can this particular law will be made the Contempt of Court Act? Obviously, which means the Parliament has the power to make law on the contempt of court. Okay, so that statement is correct. To be specific, Article 246 of the Constitution, you might not be able to remember all the articles, right? So it is okay if you are not being able to remember all the articles. Just remember some of the important articles, but just try to understand here, understand this, that the Constitution of India, it empowers the Parliament to make laws on this matter. Okay, why? Because this matter is in union list. Okay, whichever matter is in union list, obviously the Parliament has the power to make those laws, right? Then next question, with reference to the writs issued by the courts in India, consider the following statements. Statement 1, mandamus will not lie against a private organization unless it is entrusted with a public duty. Statement 2, mandamus will not lie against a company even though it may be a government company. Statement 3, any public-minded person can be a petitioner to move the court to obtain the writ of quo warranto. So we all know that we will be reading about the writ jurisdiction, right? So in this question, they are talking about two writs. What are they? That is the mandamus and the quo warranto. Okay. And the first statement says that mandamus will not lie against a private organization unless it is entrusted with a public duty. If you see, yes, mandamus, first of all, tell me what is the purpose of mandamus? Mandamus, whenever the court, the higher court, they'll be telling a public authority, okay, a government authority, a public organization, they'll be telling those, authority, whenever they are negliging, there is a negligence in their duty, this particular court will be telling them to do their duty. Okay, this is mandamus, simple, you know that. But in the first statement, they are saying mandamus will not be against any private organization unless this private organization is entrusted with a public duty. This statement is actually a correct statement. Why? Because this mandamus writ can be issued only on the public authorities, but sometimes it can also be issued to the private organizations, but only when these private organization they are entrusted with the public duty. Let us say there is a private entity which has nothing to do with the public duty, government's duty. Okay, it is completely private. Okay, then the courts cannot issue this mandamus to that particular private entity. Okay, so then what we can say, this statement is a correct statement. Then mandamus will not lie against a company even though it may be a government company. So mostly this mandamus, why, what is the purpose? To make the government entity, government authority, including the government companies. So this statement is a wrong statement because they are saying mandamus is not really not issued over the or against the government company. So this is a wrong statement. Okay, then any public minded person can be a petitioner to move the court to obtain a quo warranto. So whenever we are talking about the quo warranto, what is quo warranto basically? In simple terms, we can say that quo warranto is nothing but, let us say there is a person who is occupying a post, is a public authority. Then to question whether he what is the eligibility, whether he qualify to hold that particular post, whether to whether he can hold this particular post, to question that only this quo warranto is issued. Okay, so this particular quo warranto, this writ, any public minded people, not necessarily, okay, those who are related, any public minded person can actually move the court. Okay, so this is also a correct statement. So the correct answer would be 1 and 3, and option C is the correct answer. Okay, then, so if you see here, mandamus, okay, a writ of mandamus is command issued by the court to a public authority or a person performing a public duty. Okay, and ordering them to fulfill a legal obligation. Let's say they have a legal obligation, they have a public duty, but they are neglecting their duty. Okay, in that case, the Supreme Court or the High Court, they'll be issuing a writ on that public authority and tell them go and do your duty. Okay, they'll be telling. That is what is mandamus is. Who can be, who can it be issued against? Okay, this mandamus is issued against whom? Let us see. First, the primary targets are the public authorities like government departments, local body, and the statutory corporation. Statutory corporation matlab those corporations which are established by the laws. They are technically the government authority or the government corporations. So these government department, local body, and the statutory corporation, these are the primary targets where the mandamus can be issued against them. Okay, but also it doesn't mean the private entities are not included. Yes, the private entities are included as far as they are entrusted with some of the public duty. Okay, because why? When a private member or a private, sorry, not a private member, when a private entity is entrusted with the public duty, so then his negligence, he is showing negligence, he is neglecting his public duty and is not ready to do the duty. Okay, then obviously the court will be issuing the mandamus against this particular entity or a person, right? So in some cases it can be used against the private organizations only if they are entrusted with the public duty. Okay, let us say this private entity has nothing to do with the public duty, then obviously they can't issue any mandamus. Okay, So, public duty by law, the private company managing public utilities, and it is not applicable to the entities which are purely private, which are completely private, then the mandamus cannot be issued. Okay. Then, quo warranto. The next statement we saw, right? It was talking about the quo warranto. So, the quo warranto is a legal challenge issued by the court, obviously the High Court and the Supreme Court. And against whom? That's what. It is against a person who is holding a public office. Let us say this particular person is holding a public office. Okay. Then to question, to question their right to hold that position. How do you qualify to hold this position? Let us say some person is using some other means to hold this particular position. Then the Supreme Court or the High Court have the power to issue this particular quo warranto, this writ to question whether how this particular person is eligible, qualified to hold this particular, office. Okay. Then who can file it? Like some of the writs, it should be filed by, those people who are directly related to it, right? But in this case, the quo warranto can file by any public spirited person on behalf of a public interest. You can also go and file it. Okay. So any public interested person, public interest, due to public interest, he can be he can be filing this case. Okay. Obviously, then the petitioner does not necessarily need to be directly affected by the person holding the office. Not necessarily. Let us say this person is filing the, this case, okay, against this person. Then not necessarily he got affected by this particular person. If he has a public interest, if he wants to, if he thinks that this particular person is holding this particular office illegally, is not eligible, or he does not qualify to hold this particular office, then any public minded person, due to public interest, he can go and, you know um, file this particular quo warranto writ. Okay. Then the petitioner, yes, we have discussed this. Okay. Next, with reference to India, consider the following statements. Statement 1, government law officers and the legal firms. The government law officers and the legal firms are recognized as advocates, but corporate lawyers and patent attorneys are excluded from the recognition as advocates. Statement 2, bar councils have the power to lay down the rules relating to the legal education recognition of law colleges. So the first statement says that, let us say this government law officers, okay, and the legal firms, only these two are included in the, category of advocates. And it is telling that the corporate lawyers and the patent authorities, they are not included in the category of, advocates. So technically this is a wrong statement. Why? Both the government law officers, the corporate lawyers, the patent attorneys, all these people, everyone, unless until there is act, to, recognize, or the list of advocates, it mentions the list of advocates. Until their names are mentioned in that particular list, then yes, they are advocates. They can be government law officers, they can be corporate lawyers, they can be patent authority. So first one, this is wrong. Okay. Then there is another mistake in this statement. What is that? This legal firms, they are saying legal firms are also advocates. If you see, legal firm is an entity. Okay, it is a like entity, and there are many people who work for a legal firm. So technically this legal firm is not an advocate. Only the people working in the legal firm, they are advocates. Okay, this legal firm is not an advocate. So there are two mistakes in this particular statement. Second statement, bar councils have the power to lay down rules and relating to the legal education and recognition of law colleges. Yes, this is true. The bar councils, they have the power, okay, to lay down rules as well as for the recognition of the colleges, law colleges. This statement is a correct statement. So only B, option 2 is the option B, only 2 is the correct answer. And the advocates in India, I told you, right? The Advocates Act of 1961. This is the act, the Advocates Act of 1961. It governs the legal profession in India. This act defines who can be recognized as an advocate. And who can be recognized as an advocate? That is the government law officers, the people who are working, in the legal firms, not the legal firm itself. Okay, the individual lawyers within the legal firm, they are advocates. Okay, then corporate lawyers. Apart from that, the patent attorneys, these are the people who are, recognized as the advocates. And it is important to understand there is a distinction why between the advocate and the legal firm. What is this distinction? As I already told you, legal firm is an institution, it's an organization, it's an entity. And those people who are working, those lawyers who are working for that legal firm are called as advocates, not the legal firm itself is called as advocate. Okay, so that is the distinction. Then, Bar Council of India. So if you see, there is a entity, that is Bar Council of India. It is the apex body, okay, to regulate or make rules regarding the legal profession in India. Okay, this is the apex body. Then what is what are the functions, major functions, or which of the rules or regulations it can make? If you see here, setting standards for legal education. So first function is to set standard for a legal education in India. Okay, then the BCI has the power to lay down rules for legal education in India. This include prescribing the curriculum for law degrees. So whenever there is a bachelorate degree for law, whenever people are studying for law, the curriculum will be prescribed by this Bar Council of India, and conducting inspections of law colleges to ensure they meet the set standards. They can periodically, they can conduct inspections to the law colleges also. Then granting recognitions to the law colleges. This is one of the important function of the Bar Council of India. To grant recognition to the individual law colleges is also one of the function or the power of the Bar Council of India. Next question. With reference to Indian judiciary, consider the following statements. Statement 1. Any retired judge of Supreme Court of India can be called back to sit and act as a Supreme Court judge by the Chief Justice of India with the permission of the President of India. Okay. Statement 2. The High Court in India has the power to review its own judgment as the Supreme Court of India. So if you see here, the first statement, they are saying that, let us say there was a Supreme Court judge and he got retired. Okay, but after some time, let us say there is no, there is a need of judges in the Supreme Court. Then the Chief Justice of India, can appoint this particular retired Supreme Court judge as a temporary judge, acting judge, with prior permission of President of India. So yes, this statement is correct. We usually, whenever we read about the judges, especially in the judiciary, we'll be reading about the Supreme Court judges, right? So we'll be also reading about this acting judges. Okay, whenever, let us say, this Supreme Court judge, he got retired, but after retirement also, if there is a case or there is a need for this particular, judges in the Supreme Court, then the Chief Justice of India, with the prior permission from the President of India. This is important. They need prior permission from the President of India, and then they can appoint this particular person as a temporary judge, not permanent judge, obviously, because he got already retired, right? So for a temporary time period, he can be appointed as a judge of Supreme Court. Okay, this statement is a correct statement. A High Court in India has the power to review its own judgment, just like a Supreme Court. Is that so? In case of a Supreme Court, whenever Supreme Court passes a judgment, let us say, after a time period, the Supreme Court itself feeling that whatever judgment in previous case it has given, it is not right. It's not correct. Then what will the Supreme Court do? Supreme Court will review its own judgment. Okay, it will review its own judgment. It won't hesitate to mention that they have made a mistake in the previous judgment. Okay, it's very easy. They with time passes, obviously, many things are, everything changes. Based on that, the judgments, let us say 50 years or 20 years before, there is a case. But with current time, obviously, there is a change in the perspective also of the judges, okay, of the people along with of the judges also. So whenever this particular thing is happening, and the Supreme Court feels that this particular thing judgment should be reviewed, it's not a correct judgment, then it will review its own judgment. Okay, this power the Supreme Court of India has, but technically the High Court of India does not have this power. Then the High Court of India review whose judgments? Matlab, what I'm trying to ask is, then what review power does the High Court of India has? So technically the High Court of India has the power to review the judgments of the subordinate courts. So whenever there is a subordinate court's judgment is passed, so the High Court of India has the power to review the judgment of the subordinate court. The High Court of India does not have the power to review its own judgment. Okay, so this statement, what is this? It is a wrong statement. Why? Because they are saying the High Court has the power to review its own judgment. It's wrong, right? Then, so correct answer would be statement 1 is the correct answer. So option A is the correct answer. As per Article 128 of the Constitution, the Indian Constitution, any person who has served as a judge of Supreme Court can be appointed again as a judge of Supreme Court, but only after consultation with the Chief Justice of India and along with the prior permission from the President of India. Okay, approval of President of India. Okay, then this provision allows retired judges to be called back to serve as an ad hoc judges. Okay, they are called as ad hoc judges. Okay, we'll be reading about this ad hoc judges, and they'll be serving as the Supreme Court's judges as a for a temporary time period. Okay, not for a permanent period, for a very temporary time period. Okay, then unlike the Supreme Court, a High Court is in India does not have a power. As I already told you, the Supreme Court has the power to review its own judgment, but the High Court does not have that power to review its own judgment. Simple. Okay. However, it has power to review the judgments passed by the subordinate courts. Okay, the district courts or the session courts, whichever court, subordinate court of the High Court, it can review their judgment. It cannot review its own judgment. Okay, the power of review of a High Court is provided under Article 226 of the Indian Constitution. Okay, Article 226 is also important. Then consider the following statements. Statement 1: the motion to impeach a judge of Supreme Court in India cannot be rejected by the Speaker of Lok Sabha as per the Judges Inquiry Act of 1968. The Constitution of India defines and gives details or what constitutes incapacity and proved misbehavior of judges of Supreme Court. Statement 3: the details of the process of impeachment of judges of Supreme Court are given in the Judges Inquiry Act of 1968. And statement 4: if the motion for the impeachment of a judge is taken up for voting, the law requires motion to be backed by each house of the parliament and supported by the majority of the total membership of the house not less than the two-thirds members present and voting. Okay, so they are talking about the impeachment of the judges of Supreme Court. Okay, first statement says that the motion of impeachment of judge of a Supreme Court in India cannot be rejected by the Speaker of Lok Sabha as per the Judges Inquiry Act 1968. So technically, yes, the Speaker of India does not have the power to, reject the impeachment process. Okay, to reject the motion of impeachment process. Then who has the power? Obviously, the Parliament has the power. Okay, then this statement is a wrong statement. Then second statement, the Constitution of India. Okay, this statement is a correct statement. Why? Because they are technically saying the motion to impeach a judge of Supreme Court of India cannot be rejected by the speaker. Yes, it cannot be rejected by the speaker. So yes, this statement is a correct statement. Then the Constitution of India defines and gives details or what constitutes incapacity or proved misbehavior of judges of Supreme Court. So again, whenever they are telling this is mentioned in the Constitution of India, this is given by the Constitution of India, but obviously in this case it is not very easy to recognize, but still if you see here, this proven misbehavior or the term incapacity, only these terms are given in the Constitution of India, but it is not clearly mentioned what this particular terms refer to, or what things are considered as the proven misbehavior or the incapacity of the Supreme Court judge. Okay, so this statement is a wrong statement. Third statement, the details of the process of impeachment of the judges of Supreme Court of India are given in the Judges Inquiry Act of 1968. Yes, this is true. It is not mentioned in the Constitution of India. It is mentioned in the Judges Inquiry Act of 1968. Okay. Then, fourth statement says that for the removal of the judges, Supreme Court judges, what majority is needed? You might have read it. A very high majority is needed. One of the very high majority. What majority is needed is majority of more than 50 percentage of total membership of the house along with more than two-thirds of present and voting. Okay, this majority is actually needed to impeach or remove a judge of Supreme Court. So yes, this statement is also a correct statement. So what is the correct answer? 1, 3, 4. Option D is the correct answer. So role of speaker, as I already told you, the speaker of Lok Sabha cannot simply reject an impeachment motion. He does not have that power to like abruptly reject the impeachment motion. Okay, then they have the authority to examine it for technical flaws. Yes, he has the power to examine whether there is any technical flaws in the motion and like improper formatting or missing information. Let's say there is some missing information or any improper formatting, he can be, he has the power to rectify it, but he does not have the power to reject the motion itself. Okay, however, the final decision of whether to admit the motion for consideration rests with the house itself. It is resting with the Lok Sabha, Rajya Sabha, whichever house this particular motion is actually being introduced. Okay, then defining the misbehavior and the incapacity. So the Constitution of India, it actually uses the term, it mentions these two terms, okay, as the ground for removing the judges of a Supreme Court or High Court. Okay, but they does not, define or they does not mention what are the things which are considered as proven misbehavior or incapacity. Okay, technically, the Judges Inquiry Act 1968, this particular act actually defines, or interprets what and all comes under these two terms. Okay, so what and all comes into these two terms? One is corruption, abuse of power, proven mental or physical inability. Okay, some people obviously proven mental or physical inability to perform judicial duty. So these are some of the category cases where it can be said that they are incapacity or proven misbehavior. Okay, and this is mentioned in the Judges Inquiry Act of 1968 and not in the Constitution of India. Okay, then this Judges Inquiry Act of 1968, this act serves as a key legal framework outlining the entire process of impeaching of judges in India. Okay, this particular act clearly talks about impeachment of the judges in India. Okay, then in detail the steps involved from initiating the motion to the conducting an inquiry by the committee and finally voting on the removal of a removal from the both the houses. All this procedure is clearly mentioned in this particular act. Okay, then and the required majority, as I already told you, it needs how much majority? Majority of more than 2/3 of present and voting plus more than 50 percentage of total membership of the house. Okay, this is a majority which is needed for the impeachment of a judge. Okay, you can read this. I have clearly told you. Okay, then next question, with reference to the Constitution of India, prohibitions or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. It could mean which one of the following? Option A, the decisions taken by the Election Commission of India while discharging its duties cannot be challenged in any court of law. Option B, the Supreme Court of India is not constrained in the exercise of its powers by the laws made by the Parliament. Option C, in the event of grave financial crisis in the country, the President of India can declare financial emergency without the counsel from the Cabinet. Option D, state legislatures cannot make laws on certain matters without the concurrence of the union legislature. So technically they are talking about Article 142 of the Indian Constitution. Okay. So this particular article, Article 142 of Indian Constitution, it empowers the Supreme Court. It gives the power to Supreme Court to, deliver proper justice in any particular case. The Supreme Court has a extraordinary power. Okay, that's what this Article 142 says. So in the question what they are saying with reference to the Constitution of India, prohibitions or limitations in an ordinary law cannot act as a prohibition or limitation on the constitutional power under Article 142. So that's what they are saying. Let us say there is an ordinary law and this ordinary law is having certain limitation or prohibition. Okay, but Article 142 gives a certain extraordinary power to the Supreme Court of India. So which of these following statements are correct or saying this particular thing which I have told you? So if you see your option B, the Supreme Court of India is not constrained in the exercise of its power by laws made by the Parliament. Yes, that is the real meaning of this particular thing. Why in Article 142, the Supreme Court of India is given an extraordinary power, for delivering, proper justice. It is not confined, it is not limited to the laws made by the Parliament or the state legislature. That's why this particular statement, option B, is the correct answer. See here, Article 142 of the Indian Constitution empowers the Supreme Court to pass any order necessary for doing complete justice. There is a case and the Supreme Court has to deliver complete justice, then the Supreme Court of India is not limited by the restrictions placed by any parliament's law or any law which is made by the state legislatures. And this power is meant to be extraordinary and can be used in situations where existing laws might be inadequate. Let us say there is an existing law which is inadequate. Obviously, in that case, this extraordinary power can be used by the Supreme Court of India. Okay. Then, ordinary laws are statutes passed by Parliament and state legislature. Obviously, the statement says that the limitations in the ordinary law cannot restrict the Supreme Court's power. Yes, any limitation which is mentioned, restriction which is mentioned in the ordinary law, either by parliament or by the state legislature, it cannot restrict the Supreme Court of India in delivering the complete justice. Okay, then this is mentioned in Article 142 of the Constitution. Okay, that's what they have given. You can read it. So with that, we have come to the end of this video. So that's all for today's class. We'll be continuing this particular topic. We'll be seeing in the next class. Thank you, students.